Good Friday afternoon to everybody. We've been absent for a bit. Yesterday, Keith and I went up to Palm Springs to do a mediation.
Yeah.
And there were, I don't know, a dozen or so attorneys, a dozen or so different parties. And we were told the case would not settle.
Yeah.
And so what happened? Did we settle?
Well, we settled around 6:30 and then it unsettled around 8:30 and then it settled again around 10:30 and then everybody had to argue over commas. And so, yeah, we got out of there around 2 a.m.
2 a.m. out of Palm Springs. Yeah.
So we're, maybe not as rested as perhaps we normally would be.
Yeah. And it doesn't matter what time I go to bed. I always wake up at like 6. And that's,
same here.
Yeah, it's terrible. So I'm really tired right now. In fact, I can't focus. So apologies if I get names and dates wrong today. But there has been a flurry of filings in the Lively versus Baldoni matter, and we wanted to cover 3 of those today and then a few miscellaneous items. Before we do that, just want to point out the jury pool. We have Chillaxin here. Yes, like the video, best law tubers here. Thank you so much for that kind comment. And then one of our regulars, Roman, is here, and he says, I don't think there was a subpoena. I know you're going to talk about that later.
Yes, I am.
Another name that I'm getting familiar with, Bridget Valentine. Oh my God, I'm waiting for this all week. Thank you, Bridget. Appreciate that. And Gwen Campbell, yay, been waiting each day for you. Oh, each day. Well, all right, Gwen, we're glad we're here. And then we have Tejesty Hale. Boy, Tejesty is kind of upset with Judge Lyman denying the extension, and you'll talk about that in a bit.
Yeah, right? I have some thoughts on that as well. And, it's funny because, go ahead.
Go ahead.
Well, today we don't have any big entrees. It's just kind of a bunch of hors d'oeuvres, but it is interesting. There's a lot of interesting things.
There's a lot of big things happening.
Yeah.
And we're seeing some things from the judge, and I know we're going to see some more from the judge here in the next week or two.
Oh, yeah.
Jeanette B., I'm hoping Lyman's denial means that he's just trying to keep everything on track here. So that's an interesting statement. Bridget again. Thank you, Bridget. I think the New York Times will be dismissed, and she wanted to know, what does everybody else think? That's an interesting comment.
Let's start the poll.
Christine Newecki, so ready. Thank you, Christine. We're ready too. And somebody here, Tiger Scorp, they've been waiting since 10:23 for this. So this is a very precise person.
Yeah.
10:23, not 10:20.
It's very detailed oriented. I think that's probably when we posted that we were going live. And we're at a real disadvantage today because we don't have producer Eric with us, but we're going to do the best we can.
Yes, we are.
Looking at comments.
All right. So do our best. Eric's not here today. Keith, I think the first thing we want to do is we want to pull Blake Lively's response to the Wayfair opposition. And this one's near and dear to my heart because we have Ezra Hudson, who apparently I'm a fanboy of. I think Ezra Hudson may be one of the best writers I've come across in quite some time. And if this truly is her writing, she's signing this. Kudos to Ezra. Doesn't mean that I agree with her to the jury pool. It just means that she's
She's good at what she does when it comes to legal writing. I mean, it's definitely probably the best legal writing we've seen in the case. And I know people don't like when we praise Ezra Hudson, but you got to give credit where credit's due, and credit's definitely due here. She is bringing up some very interesting arguments. And the other thing I would say about this reply, just as an overall thought, is that this is the type of reply that's done the way a reply should be done.
Because it's so long?
No, exact opposite.
Oh, it's short.
Yeah. Reverse that.
All right.
It's short. It gets directly to the issues, and it hits them hard, and just boom, boom, boom.
She also just points out the things that are raised in the opposition and doesn't go back and regurgitate all of her arguments in the moving papers.
Yeah. So, I mean, if you want a sample of how a reply should be, this is it.
All right. Keith, real quickly before we get any much further here, there's an introduction. I don't know. Did you want to go over anything on page 1?
Let's see. No.
Okay. And I wanted to go over something quickly on page 2, but is there anything you wanted to go over there first?
Just, kind of what you have highlighted there already. So what do you got?
Is that what you want to go over?
Yes.
Okay. I'll pull it up for you. Why don't you take a stab at it?
Yeah. So essentially this goes to that argument. I'm laughing because the way that she phrases this, I mean, in 2025, wives are not responsible for their husband's words. I mean, just take that statement outside of this case. That's just kind of a funny thing to hear. I mean, that's true, and it should be true. There's no reason why wives should be responsible for what their husbands say. It's incredible that Baldoni, a person who calls himself a feminist, would take such a position. So there's a little bit of a jab here, obviously. There's a little hyperbole, but this is going directly to the argument that I thought the Baldoni did a really great job of on this opposition, which is trying to link Blake Lively to Ryan Reynolds' statement. And Ryan Reynolds' statement is he went and told WME that Baldoni is an S predator, and trying to make that connection. And I thought that was a really creative thing in the opposition. They're punching back and saying, wait a minute, just because they're married, Lively as a wife is not responsible for what her husband may say. And so this is going to become an important part of this reply.
So there's two of my favorite sentences in this reply are on the same page number 2. And this is one of them. And the reason I like it, it's a statement of rhetorical indignation with mild sarcasm mixed in. And it's a biting statement. It's a biting statement. It's made more for public consumption than it is for a judge. I don't think a judge is going to be swayed by this, but it's really saying, in other words, are we still dealing with this? And it's painting Baldoni in the worst light you can by saying, hey, you always say you're a feminist. You say you stand up for women's rights, but yet you're not doing that in this case. I mean, you're essentially saying that our poor little client is responsible for the things that her husband says, which is something that you would have seen at the Salem witch trials or something, back in the day.
Yeah, you make a good point, because everything that's before the semicolon there is actually legally relevant to this case. Wives are not responsible. Everything after, it's incredible that Baldoni, a person who calls himself that really is hyperbole. It really has no relevance to this particular legal argument. I think what really has relevance is wives are not responsible for what their husbands say. And that they did not allege that Ryan was an agent of Blake Lively. That would have been more relevant to the legal argument. But that's not, I mean, obviously that's not what they're trying to do here.
Yeah, I think what the key point they want to take is that this position is not just legally unattainable, it's morally wrong.
Yeah.
Okay. Jury pool, we're not saying we agree with this. We're just saying this is a really good piece of writing that pulls this together and tries to present a frame for the way that she's going to continue to go through this argument.
And tries to bring morality into the legal argument, which is not the legal standard, but it is interesting that they try to do that.
All right, there was my second favorite sentence, but Keith, if there's something you want to add to this, please do.
No, let's see. The meritless... Yeah, why don't you go? This was a very well drafted sentence. Why don't you go over it?
Okay, so the meritless FAC, which Keith, is that the filed amended complaint?
No, it's still going to be the first amended complaint.
Okay, I got to get that right. The meritless first amended complaint is a classic case of retaliatory litigation, cannot be saved by amendment. In other words, Justin Baldoni can't get a second or third bite at the apple to do a new complaint here. It just can't be saved altogether, and it should be dismissed with prejudice. So again, this is one of the best well-constructed sentences you can see as a good writer. And again, just looking at it from a writing standpoint, not looking at it is Blake Lively right here through her lawyer in the argument she's making. Just look how strong this is. So you've got the meritless First Amendment complaint. Those are 3 words. And really what we're saying there's a strong legal conclusion, meaning that the term meritless dismisses the entire complaint as having no legal or factual basis. So it's just 3 words. In 3 words, the meritless First Amendment complaint is a classic case of retaliatory litigation. Classic case just means this is a textbook example, and that the lawsuit was not really filed to seek justice because it's retaliatory. It was to punish somebody because they filed an SH claim against this person. So the purpose, again, is to cast Baldoni and his lawsuit as abusive, not just meritless. It's meritless, but it's also abusive. And again, this is just, if you want to see strong writing, this is the kind of writing you want. I wish we saw a little bit more of this from Brian Friedman's side. I mean, I think they're good writers. They get the job done. They're obviously, all these people are bright. They're very smart. They're very educated. But I haven't seen somebody like Ezra Hudson before. The way that she is able to encapsulate so many concepts, so much rhetoric in such a short, punchy sentence and be very effective with what she's communicating.
Where you usually see this is in appellate writing, and notice that she slips in the cannot be saved by amendment. And so what she's trying to say is they should be dismissed without leave to amend. That's unlikely to happen, but still she's slipping it in there. And that's what's so strong about that. Look what else there's. If we're done with that, there's one other thing I want to show on this page.
Sure.
the paragraph before this that starts with realizing, and at the everything after that M dash. So where it says frivolous, and then there's an M dash, and it says the First Amendment empowers legislatures to protect victims' First Amendment rights via fee-shifting rules designed to deter retaliatory litigation.
Right.
Now, this is what happens when you're a really good writer. She's putting in a concept here that says that the First Amendment actually empowers things like 47.1 that gives fee shifting. Now, we know that 47.1 does more than just fee shifting. It also has treble damages. It also has punitive damages. And we have identified that those are problems, I think, with the statute. Now, she doesn't mention those two things. She only talks about the fee shifting. So this is what I think a good drafter can do, is kind of frame the issue as the First Amendment literally empowers legislatures to do things like pass 47.1 with fee shifting. Well, it's not just fee shifting, is it? But that's going to be the focus.
So we have perfume therapy saying irrelevant. I think that's irrelevant. Ezra uses AI. I guarantee it.
Could be. I don't think so, but.
Well, I mean, using AI as a tool is not a bad thing in and of itself, but I haven't seen other lawyers write with AI. If she's using AI to do this 100%, which I disagree with, I haven't seen other lawyers replicating that in this case.
No.
So, all right. So let's move on. Where do you want to go from here? Well, let me just tee this up, Keith. So let's go to page 3. She sets out her argument. Is there anything you want to go over there, or do you want to move on to the next page?
No, I want to we can move on to the next page.
Where do you want to start? Page 5?
Let's see.
Well, let's start with page 5, and then we'll come back to. So here we go. Again, good drafting,
privileges.
Super good drafting. Look at just the argument in the heading. The Wayfarer parties cannot evade the privileges. Just the word evade, escape, get away from. You're trapped. It's a really strong way to frame that argument. And then she says the opposition fails to rebut the application of, and then she gives a litany of reasons, and she stacks them together to give them more power because there's so many. It's like getting whipped 3 times rather than just 1 time.
That's a rhetorical device. So you always want to say things in at least groups of 3. So fair reporting, litigation, and SH privileges, all of which bar the defamation claims, because it obviously sounds more weighty to group them together.
All right, so then we're going to get to the first privilege. And I, again, do applaud against it. Everybody can call me a fanboy, that's fine. But this is what you're supposed to do in a reply. She quickly gets through this. She doesn't regurgitate all of her arguments that she made in her 12b6 filing. She immediately jumps in and she starts talking about the litigation privilege. And what does she say there, Keith?
Well, she's saying that the Wayfarer parties failed to identify a statement outside of the legal complaints and the CRD complaints, and therefore everything's covered by the litigation privilege. I don't entirely agree with that, but the way that she's, again, framing it, I mean, I think she's done a very good job of framing that, look, everything is either in the legal complaints or in the CRD complaint. And then, I like what you underlined there. So the Wayfarer party's baffling argument that Miss Lively did not seriously consider litigation because she waited to file suit for 11 days. I don't think that that's a great argument that I think the Wayfarer parties did make, but I think they had another good argument. And that is that there were other things outside of the legal complaint. Supposedly there were thousands of pages of text and emails. And so I think that this is missing some of the material that was allegedly provided to the New York Times.
I've always felt that the litigation privilege is something you want to throw out here, but I really think this case really all comes down to 47.1.
Yeah.
And so that obviously has much more, it's more protective than the litigation privilege because it doesn't just deal with things that are filed or anticipated to be filed. It can be anything as long as Blake Lively or any woman is reasonable, or man is reasonable in their complaint of SH, and then also they didn't do it with actual malice.
Yeah, no, I think you're right. And, the litigation privilege under Civil Code Section 47 really protects just specific things that are filings. But 47.1 blows that wide open.
I'm talking about 47.1. So we get to, again, a very quick analysis that she does. And she points out that the Wayfarer parties actually quoted 47.1 in their opposition at page 27. And so she says that, they actually concede this point. But they say they essentially advanced two challenges. And we called this, when we first saw 47.1, when the 12b6 was initially filed by Blake Lively, we said, well, it looks like they're going to have to, they being Baldoni is going to have to file some type of an amended complaint because they really need to flesh out, was it without reasonable basis that this complaint was made, and was there malice? Because those are the two issues that are going to come up. And sure enough, she jumps up here and says, look, the way they have it pleaded now, it fails. And what are her two arguments there?
Well, first of all, they're saying that Blake Lively had a reasonable basis to complain about SH and retaliation. So in other words, every time there's a let's take a step back. Remember that 47.1 covers any communication regarding an incident of SH. I mean, think about how broad that is. Any communication regarding an incident of SH. Doesn't matter if it's specific, general, any incident of SH. And so what essentially they're saying here is that every statement that they're pointing to that Lively made is really a communication regarding an incident of SH. Therefore, it comes under the umbrella of the SH privilege under 47.1.
And she actually points to page 26 and 27 of the opposition, which I'm putting up on the screen now. And you'll remember, Keith, there was just a litany of arguments that apparently were made by Miss Lively in her complaint. And these are things that she believed were SH. And so what Ezra Hudson is saying is, look, all she needs is a reasonable basis to make these complaints. And here are these reasonable bases, and she's made them. And so therefore, we're good to go.
That was my problem with this list. And we talked about this list when we went over the opposition and the First Amendment complaint. And the problem with it is they are incidents of SH. That's the problem with them. That's why I liked the fact that they were trying to connect Lively to Ryan Reynolds' statement about Baldoni being an S predator, because I felt like that got you around all of these incidences of SH arguments.
Right. Okay, so we have those, and then she doesn't stop there. She says there's a second reason why, and let's just pull this out real quickly, and then we'll turn the page. Second, the parties agreed that the actual malice standard requires an allegation that give me 1 second here. Miss Lively made knowingly false statements or acted with reckless disregard of the truth. The Wayfarer parties are unable to defend the First Amendment complaint against this standard and fall back into the same strategy that plagues the First Amendment complaint, and that is generally referring to Miss Lively's accusations without identifying any specific one and flatly concluding that they are all false without explanation. So obviously that fails to establish malice. What are your thoughts there?
Yeah, and I think there are some issues, and just in terms of the allegations in the First Amendment complaint, where they probably should have made some allegations that go more directly towards malice. In the opposition, one of the big arguments that support malice is, again, the connection between Lively and Ryan Reynolds on the S Predator. But in terms of pointing directly to Lively, it's a little bit more problematic. And one of the things they point to is the takeover of the movie or the 17 points. The 17 points is a problem because that is an incident of SH. But what about the takeover of the movie? Could you point to the fact that she had an ulterior motive here, and that was the reason why, she made certain statements? I'm not sure that the problem is I'm having a hard time connecting them. I think that it could be fixed with an amended complaint by Baldoni, where he simply comes out and adds allegations that go more directly towards malice.
So he's going to have to, I'm guessing there'll be some type of an amendment filed here. Maybe I'm wrong. Baldoni is going to have to address the reasonableness standard, and he's going to have to address the actual malice standard.
Yeah, and he literally has to say that at the time that Blake Lively made these statements, she knew them to be false or acted with reckless disregard of the truth. And there are statements in there that seem to go towards that, but I don't think they're as clear cut as maybe they need to be.
So my feeling is that if they're given the opportunity to do a second amended complaint, which judges are going to probably allow at least one more amended complaint before they start carving up the causes of action and throwing them out. I think they're going to have to really address this reasonableness standard, and they're going to have to show actual malice. I think they complete it, and I think they can get past the 12B6 phase, but then they're going to have to prove it, and that's going to be the issue.
Yeah, 47.1 is going to be a problem throughout this whole litigation. But just in terms of getting past the motion to dismiss, I think this can be fixed. And often courts will give parties opportunity. Courts don't want to dismiss lawsuits at this stage. That's not what they want to do.
All right. So next, we get Miss Lively is not liable for statements that she did not make.
Yeah.
And so they run through this quite a bit. I don't know if you wanted to look at this.
I do, just because, again, you can see that in another stunning example, Baldoni's fall feminism. So once again, they're trying to bring the moralistic side into this in terms of the arguments, not the legal standard, but sometimes you bring that stuff in because it becomes the persuasive argument, even though it's not the legal argument. And then he argues that his wife should be liable for her husband's statements. Fortunately, that is not the law today. I mean, I think really what they're getting at is that there isn't a specific allegation in the complaint that says that Ryan Reynolds was acting as an agent for Blake Lively. Now, they're saying that in the opposition. They're coming in the opposition and saying that he represented her and, making all of these arguments. And they're just arguing back that, yeah, but you didn't make the right allegation. And again, 12B6s are very technical. And so we're just looking at what is alleged in the First Amendment complaint. And they might have a point. They might need to fix that one up a little bit and specifically point out that Ryan Reynolds is an agent of Blake Lively.
And remind us, the jury pool, what the standard is at a 12B6. Does the court have to accept everything that Justin Baldoni says in his lawsuit as being true?
The court does, yeah. So really it's just a matter of fixing up the allegations. And once there's an allegation that says Ryan Reynolds at all time during this time period was acting as an agent and representative of Blake Lively, that would be enough of an allegation to solve this problem.
I see, but there's still an issue that she's married to him, so there's spousal privileges, and there's questions about his interactions with WME because they were his agents too. And so just because he's talking to them doesn't mean he's necessarily talking on behalf of Blake Lively. So you would have to make some pretty strong claims here to get past that, right?
I think so. And I think you'd have to specify exactly what you said, that yes, he also is represented by WME, but in addition to that, he also is acting as an agent and representative for Blake Lively. And they did point that out in the opposition. It'll be interesting to see if the judge looks at the opposition and says, I think it's enough. But on the other hand, it can be fixed, go and do an amendment.
So they also have this ratification issue. And what are your thoughts there? That, they're saying essentially there's just not enough facts to show that she ratified these statements of Ryan Reynolds.
Yeah. I mean, so that was the issue of you either have to approve what your agent's doing, or if it's something that goes outside of what your agent's authority was, you have to ratify it. I feel like the ratification is there because all of his statements were in her. His actions were in her pleadings. I guess the S predator wasn't in her pleadings, but I feel like she ratified it by adopting and placing all of that in the CRD complaint and in her lawsuit. So I'm not so sure about that. I think the bigger issue is, have you properly alleged that there's an agency or representative capacity?
All right. Gigi says, do you have any speculation as to why Brian Friedman is trying to push 47.1 when it seems near impossible to overcome?
You don't have a choice. If you're going to keep your defamation against Blake Lively under California law, which I think you almost have to do because Friedman argued California law for the New York Times defamation suit. And there's one other party defamation suit. The other PR person, the name's
Leslie
escaping me.
Sloan?
Yeah, Leslie Sloan. Sorry, 2 a.m. is kicking in. So because you're going to be probably most likely stuck with California law and defamation, you're going to have to, I think, argue that 47.1 is in some ways unconstitutional, or you're going to have to argue those two exceptions, malice or not reasonably making an SH claim.
All right. So next, Ms. Lively is not liable for the alleged Sloan statements. What are your thoughts there?
It's the same argument. So it's going back to now, I think that's a little different in my mind. So when you're talking about not liable for the Sloan statements, clearly Sloan was an agent of Blake Lively. I don't think there's any doubt about that. She actually hired Sloan. Sloan was, if not an employee, at least an independent contractor that worked for Blake Lively. I think
probably an independent contractor, I would think.
Yeah, but that's still an agent. And so I think that it's going to be a little bit harder to say that she's not an agent and therefore not liable for what she says. I think that's a much harder argument than the Ryan Reynolds one, based on the current allegations.
Okay, and again, we get to the end of the complaint and we see, once again, we're starting to kick a dead horse here, but this 47.1 just will not go away. You do wonder, did Brian Friedman and team know that this law was on the books as of January 1, 2024? Keith, you and I, we handle cases all the time, and there's new statutes every year that surprise us during a case.
Especially in California.
Maybe not to the extent this one has surprised everybody, but this one, obviously their response was very strong, saying it was unconstitutional, that there's a doctrine out there that doesn't allow it, which we're going to get into here right now. This is something that Blake Lively had to respond to. Brian Friedman's arguments that it's unconstitutional and that there's this doctrine that doesn't allow this to go forward because it squelches or takes away Baldoni and crew's ability to bring a claim against somebody and to petition the courts. And so what is the response here?
Well, once again, they're starting with the moralistic argument. So from their point of view, they're going to talk about, after years of promoting themselves as supporters of women and victims of abuse, now Baldoni, Sorowitz, and Heath attack a California statute that was drafted specifically to protect victims from abusers who weaponize defamation law.
Can we just stop there for a second? So normally let's take it outside this case. If there's a woman who's being sexually harassed at work, and let's say that you're sexually harassing a woman at work and you're just a horrible person to her. You touch her inappropriately, you whistle at her, you grab her in areas you shouldn't be grabbing her. And she makes, let's call it $25 an hour. She lives in an apartment. She doesn't have a lot of savings. Maybe she has a couple kids at home. She doesn't have a husband any longer. She doesn't have the resources to fight someone like you because you're kind of a powerful guy. And so she sues you for SH. Mm-hmm. And prior to suing you for SH, she goes and talks to one of the publications here in town and gives them all the text messages that you've sent her that are highly inappropriate and offensive. And you get the lawsuit and you're angry and you're really angry about getting that lawsuit. What is it that you want to do back to this person who just sued you?
Yeah, sue for defamation. These are all lies. And so I want to sue for the defamation that's been done to me by trying to ruin my reputation.
And if you sue this person and they don't have the resources to continue on in litigation, what happens to that case?
It goes away. I mean, you literally can sue somebody out of existence in terms of, legally speaking.
And when you also sue them, do you get a right to take their deposition and put them through the paces?
Yeah, you can take their deposition. You can do subpoenas. Sometimes in a lot of these SH claims, and we've seen it here too, there's claims that there was a psychological harm. So now you're going after their medical records. I mean, it can be very invasive.
It reminds me a lot of the movie from Jodie Foster in the 1980s where she was a rape victim.
Yeah.
And I don't know, can we say the R word?
Well,
I'm going to say an R word.
We do the best we can.
Okay, we're doing the best we can. But she was put on trial essentially. And so that's where the R shield laws come from in many states. And that is, we want to protect victims of R because it's such a horrific thing to have to go through. And we want those victims to come forward because we want their predators, the perpetrators of this, we want them caught and we want them put in prison. We want them put away. But what happens is, or what used to happen is that the woman would be put on trial for what type of clothes she wore, how many people had she slept with, in the last year. And these are questions that were asked at deposition over and over again. They used to take 4, 5, 6 day long depositions of these people, and they would, go into their personal life and give them a very tough time. And so you can see the reason that 47.1 is there, right?
Yeah, there's going to be many situations where 47.1 is a good law and it makes perfect sense and it protects victims. But there's also going to be situations where it's going to have an adverse result that was not what the statute was necessarily designed for. And that happens with a lot of different laws. I mean, it's not just 47.1, but this one is particularly unique. I think this one's particularly unique because it's not just a fee shifting statute where the loser has to pay the fees, or for example, in California, anti-SLAPP, you have to have a showing that there's some likelihood that you're going to succeed on your lawsuit. That would be different because I think that's already kind of accepted and it makes sense. The problem I have with 47.1 is it then imposes treble damages and punitive damages. I think that goes too far.
It might go too far, but let's go back to the example of the secretary that you were sexually harassing that doesn't have resources, and you want to now bury this person, and you might actually feel really offended by this. I mean, I'm not saying, you might think, God, I was so nice to that person.
Well, I would, because I don't actually do that, but yes. But in your scenario, yes.
In my scenario. And so you can use me as an example next time. Fine, okay. Yeah. All right. So, so in that example, though, if you were to try to sue her into oblivion or drag her through the process of going after her for defamation, now as of January 1 in 2024 in California, setting aside the damages issue, you're not going to be able to do that.
Not without a massive risk. And really what the legislature is saying is we don't want retaliatory defamation lawsuits filed at all. That's what they're really saying.
So the reason the jury pool, I think, has such a problem with this case is this statute wasn't intended to protect very famous and wealthy people. It was meant to protect people that didn't have the means and the resources for continuing on in litigation.
Yeah, especially if people are making claims that based on, the evidence don't appear to be legitimate. And, that's where it gets very frustrating.
But there are no exceptions into who can ask for protections under this statute. And so if Blake Lively or any other wealthy, famous person wants to use this statute, it's available to them. Is that right?
Yeah, as long as they don't fit within either the malice or the reasonable. But yes, in terms of, it's not like this only applies to people who have a net worth of, a certain amount or less.
But you can understand why the jury pool and many people are upset about the fact that Blake Lively has been able to use this 47.1 really effectively against Justin Baldoni.
Yeah, absolutely. And it gets frustrating. And, even the moment that we first pointed it out and started saying that it's a problem, the reason it's a problem is because we're concerned for Baldoni and the Wayfarer parties and what this means to them and the risks that they have to take on and the risks they have to live under because of it. So it's a big issue. But be that as it may, it's here, and you can see that Lively is going to take full advantage of it in her arguments. And, it makes sense that she would. I mean, why wouldn't you if it's there?
It goes on to say, contrary to their self-serving contentions, 47.1 is not a procedural statute. It's a substantive privilege against liability. Why are they making that distinction between procedural versus substantive?
Well, we talked about the Noor-Pennington doctrine last time. And so that was a doctrine that says that the federal courts do not have to listen to state law when it comes to, certain fee shifting. And you can see here that they're going to argue that Noor-Pennington challenges without merit. But really what Noor-Pennington stood for is the federal court doesn't have to follow some of these fee-shifting statutes that the states have. But they do follow it if it's a part of substantive law. What does substantive law mean? Like, what are we saying when it's the substantive law?
It's at issue. It's the issue in the case.
Yeah. So like when we sue for financial elder abuse, we can get damages for somebody who abuses an elder, and we can also get triple damages or double damages or triple damages, depending on what statute you're using. That's part of substantive law. That's a penalty that somebody who abuses an elder is going to pay. And so that's what they're trying to recast this as.
All right. So they weren't as impressed with with Noor-Pennington, and she finishes that off. Okay. So that kind of concludes. I don't know if there's anything else you wanted to add on the Lively reply.
Yeah, I think part of this argument, they're saying that, look, even if the treble damages and punitive damages are too much, the statute still gives a privilege and the fee shifting should still be allowed. And so I thought that was a little bit of a concession of, even if the statute goes a little far, at least the base privilege should still apply. And so I thought that was interesting because, again, the problem I have with 47.1 is the treble damages and punitive damages. It's very unusual. I don't think I've seen it in another statute. Have you?
I have not. No, I think our financial elder abuse is the closest I've seen with the double damages, and then you get Penal Code 94.6, which deals with treble damages.
But that's not damage for filing. That's a damage for actually being found liable of abusing somebody.
Yeah, it does seem like, if Justin Baldoni truly had claims of defamation here, it does seem like it is taking away his right to petition and have those issues heard. The problem is if you open that door just a little bit, then that means other people are going to be able to use that door the same way. So the legislature's trying to do their best here. Again, you and I have opinions that we probably won't share on everything that California regulates. They regulate just about all of our aspects of our life. And it looks like there were some good intentions with this statute, but it looks like it's being used here very effectively by someone who may not need the protections of that statute.
Yeah, and there's an old saying in the law that bad facts make bad law. And so, there's some situations where it's just not going to have the result we were hoping for.
All right, let's see. Do we have anybody going on here? All right, I can see that I'm not as good as producer Eric at this, so I'm going to move on and we'll get to some other comments. Okay, so let's jump into now this. We are being fair here, I think, Keith. I know some people are going to be upset at our analysis of the reply, and some people said, "Get over it. We know you love how she writes." I don't get over it. I think she's a great writer. I'd love to meet her. I'd love to have her on this show. I'd love to talk to her about how did she become such a great writer? What books does she read? What's her process? How does she outline? How does she attack these projects? I mean, those are all things that I would love to know.
We also pointed out a few holes in her argument. Even though the writing's spectacular,
yes,
there are a few holes in the analysis.
But let's point out something that you and I both, I know, are upset about, and that is we both have a sensitive spot for a guy named Jed Wallace in this case.
Yeah.
And we haven't gotten to his opposition yet, which we will in a few minutes, but Jed Wallace had a medical condition and it was blocked out by the court somehow, some way. And then Blake Lively and her attorneys, which includes Ezra Hudson, I don't know if Ezra Hudson was responsible for this, but the attorneys, they disclose this very sensitive medical information in a filing that they do in the Texas federal case.
Yeah.
And at the same time, they were crying like little babies up at the federal court with Judge Lyman saying they needed an attorney's eyes only designation on sensitive materials. Right. What the heck is going on there? Yeah. Why is it that Blake Lively and her lawyers thought it was appropriate to file Jed Wallace's private medical conditions for the whole world to see?
So, well, they filed 800 pages. So I guess my first question is, did they do it intentionally or was it an oversight? Yeah. Okay. And then the second thing is, well, sure. I mean, I don't have any problem whatsoever exposing your medical records. I don't want to expose mine.
Right.
So
right.
I think that's what it comes down to.
Yeah. If I could give you the attorneys that represent Blake Lively just 2 cents in this case, is everybody's going to question everything you guys do, because you guys are on the side that the PR side has not won. People like Justin Baldoni. He's a likable person. They don't necessarily like Blake Lively.
And the evidence has not been in their favor so far that we've seen.
It hasn't. You need to be above board in everything you do. So cut out all the snarky comments in your filings, because I think you think they're being effective, I guess, as a PR campaign. Make good, strong legal arguments like Ezra Hudson and see where they fall. But don't disclose some poor guy's medical condition to the whole world when you've been belly aching about all of your famous friends that you're going to have to disclose their addresses. By the way, they didn't just disclose his medical records. They disclosed his address.
Oh, that's even worse.
So, I mean, this is a big case. Everyone's eyeballs are on it. So you got some people driving by Jed Wallace's house. Hey, let's go see if we can talk to Jed Wallace about this case.
That was another argument they made too in New York. Lively said we have to have the attorney's eyes only because for security purposes, we can't give out addresses.
Right. So in my opinion, Lively attorneys do better. Do better in your redacting. Look at your stuff before you file it. If you want protections, privacy protections, give them to other people too, out of courtesy.
So practice what you preach.
Yeah, and there's no benefit they got for filing that other than to be ornery in my mind. Maybe it was an oversight, Keith. If it was an oversight, it was a big one. And do better.
You can't have that kind of oversight.
Yeah.
That oversight's inexcusable.
Yeah.
And so even if it was not intentional, it's still not an excuse for having done it.
It's almost as bad as doing a signal chat and including, secret war plans that you're.
Are we moving on to that?
Okay. All right.
Not prepared to talk.
You're not prepared to talk about that. Okay. Let's jump into Ryan Reynolds now, just as, a 30,000, 40,000 foot view compared to Ezra Hudson's drafting. Now, this is Michael Gottlieb that drafts this. Apparently, his name's signed to it. There may have been other people involved. Can you tell a difference, in your opinion, between the drafting?
Substantial difference. Yeah, I mean, this reply is just not anything near as good as what Ezra Hudson puts together. And maybe part of it is because the argument for Ryan Reynolds is not as easy to make. Think about it. Lively has 3 different privileges that working right up her alley. Ryan Reynolds doesn't have that. But even so, I found these arguments to be quite dense. They were quite frankly hard to even understand. And I feel like I'm pretty decent at being able to understand arguments, but they were really hard to get through. And I don't think that they really were focused and punchy the way that the reply for Lively was.
All right. So, I don't know where you want to start here. I first of all, I want to say that Mr. Gottlieb and his crew of people are all very bright lawyers, because I can see this is well researched. It's very substantive. It's a little clunky from when I read it. I don't read it as smoothly as I read the other reply that Ezra Hudson drafted. They make some good points in here, but they also make some points that are a little bit confusing.
I think their analysis is not as good. And so I really just have two things I want to point out.
Sure.
One is on page 4 under
right.
subsection D.
All right, let's pull that out.
And this goes to the whole argument of, hey, you can't sue Ryan Reynolds for defamation because it was unactionable opinion. It was just his opinion that Baldoni was an S predator, and he's able to express his opinion. You can see there that they say that the Wayfarer parties argue that context demonstrates that the statement implied undisclosed facts. But what their argument is, neither the opposition nor the First Amendment complaint identifies which undisclosed facts may have been implied. That's not true. The opposition does specify which undisclosed facts. So if I go around calling you an S predator and I...
Wait, is this my turn to be...
Yeah, now it's your turn.
Okay, all right.
Buckle up.
All right.
Now,
all right.
So I'm online or, in a news source or just out in public, I'm calling you an S predator. Do you think that implies some undisclosed fact? What do you think?
I don't get what you're getting at.
Yeah, right. Well, that's the first problem with this argument.
Okay.
Is you haven't really articulated specifically what you're getting at. That's why I find these arguments on this reply a little dense. What they're trying to say is, and the opposition said this, when you go around calling somebody an S predator, what you're really implying is that something criminal. S predator is so bad, it sounds criminal.
It certainly does.
It sounds like you did something that was really bad and it was probably criminal.
You don't come back from this.
Right. And so what they're saying is, well, just calling someone an S predator, that doesn't imply anything. Oh, it doesn't? I kind of feel like it does. So that's the problem I had with this argument is I think that's just off base.
Is there anybody you can think of in Hollywood that has been, there's Harvey Weinstein, and I know there's people are revisiting, exactly what the New York Times knew about Harvey Weinstein and whether the statements that they published were as credible as it all seemed at first. And maybe I haven't read on it myself, Keith, so Harvey Weinstein may belong where he belongs. But when I think of an S predator, I think of somebody like, what's the guy, Jeffrey, the guy up in New York that was... Yeah. How can we not?
It's 2 a.m. people.
Somebody help me. Yeah, we both have had 3 hours sleep.
Yeah.
Epstein. Thank you. You got like Jeffrey Epstein. You don't recover from that reputation.
Right.
And that's
should you.
That's what an S predator is, right?
Yes. In my mind, yes.
Yeah. And so there's criminal aspects to it. There's also just a reputational aspect that you're not part of the community any longer. Nobody wants to have their children around you. Nobody wants to have their wives or sisters, anybody around you, because that is such a toxic label.
Yeah. And I think it'd be different if Ryan Reynolds had gone in and said Baldoni's a monster.
Yeah.
That'd be different. Then the question is, well, what are you implying? Are you implying he's just not a pleasant person to work with?
Right.
Are you implying that he actually harms people? There's a lot there. But I feel like S predator is just too specific to not imply something.
And by the way, we're talking this in context of a 12b6, because again, we accept as true that Ryan Reynolds said this to somebody at WME.
Right.
When we get to trial, that will have to be proven by somebody that in fact he said that. And the other thing that they're going to have to show is that he said it on behalf of his wife as an agent in order for that statement to apply back to her.
Yeah, exactly. Yeah. So you need to be able to prove all of that. But I just don't buy this argument.
All right. What else did you want to look at
under subsection E on page 5?
I see you and we both were thinking the same thing because I have a whole paragraph highlighted.
Yeah, great and very tired minds think
yes.
alike. So yeah, this is going to the whole idea of, well, if Ryan Reynolds did say it, it was substantially true. And so the argument here, which again, I don't entirely follow, but they're saying that dismissal is warranted, whereas here, the alleged false statements, meaning the S predator statements, would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. That's, like you said, that's about as clear as mud.
Yeah, I don't.
What does that mean?
I don't follow it.
Okay. And then down below at the very end, there would be no different effect on the reader between Mr. Baldoni's own statements and those unspecified statements.
It's just a statement. Yeah, it's an argument, but I don't get it either.
I think here's what they're trying to get at. I think they're trying to get at that Mr. Baldoni made statements about himself, and they showed that in his book,
TED Talk,
his podcast, his TED Talk. And those statements would have to give everybody the same impression, which is he's an S-predator.
Yeah.
I don't buy it.
Yeah. JT says it's a word salad. And I think I pointed this out. I don't remember if it was Mr. Gottlieb that had drafted something previously, but you see this paragraph, I don't even want to start to read it.
Yeah.
It's got, all these sites through there. You got quotes, break it up into two at least, so it looks bite-sized so that I can jump in there and figure it out. But yeah, again, this drafting, I do believe these are all very bright individuals. They've all succeeded very well in life at their positions. I just, it doesn't touch me the same way as some other writing in this case.
And you're not getting to the crux of the issue and explaining that. And I think that's the problem. So this reply is a little bit of deja vu all over again. It's kind of a rehash of the original motion, which is very different from the other reply we looked at for Lively.
And I did think it was interesting. I thought he made some good points here at the end. So we'll give him some credit for this, that, somehow, some way the anti-SLAPP statute regarding attorney's fees is applicable. And he made some decent arguments here. I don't know what the judge will do with this. Obviously, the case would have to be dismissed in order for anti-SLAPP to apply. But he does go through and point out the other side was, not reading the statute correctly.
Yeah.
Again, just look at the argument here, though. I do want to point this out. If I told him I was going to compliment him, and I apologize because I'm going to not compliment you. But notice how he writes with the quotes actually from the case. So just take that top line. Concede that the Second Circuit, quote, has not directly addressed the question of whether New York's anti-SLAPP law applies in federal quote, close quote, but urge the court to follow Librite versus Reed. I just think you should make the statement you want to make and then cite to it. And then if you must, you can put a little blurb about the case after the citation.
Yeah, absolutely. And that's why the other reply was drafted much better, because it did that. But again, I think part of this is the arguments are harder to make. I don't think Ryan Reynolds has as good of arguments.
Yeah.
And also, I feel like their analysis is just missing. It's missing the mark.
All right. So we're going to move to Jed's reply. But Keith, before I do that, I want to tease just a little bit that you and I had a conversation with somebody this morning, and we may have them on our show next Thursday. And we're very excited to have this person on. So everybody mark your calendar. It'll be next Thursday at 2 p.m. Pacific.
Tentatively, yeah. We'll confirm that.
We'll confirm it,
on Monday, I think. But yeah.
So we're going to have a special guest, and this special guest, I think, will have some interesting insights that maybe we don't have about this case and how this case goes forward. And so we'll see how that goes. All right. Next is we got Jed Wallace. And again, I don't know Jed Wallace. I've never talked to the guy. I've seen one picture of him. And I will say that I feel that this guy has just been shafted. And his declaration is so clean and concise. I just have to believe what he's saying in that declaration because it's under penalty of perjury, swearing that he's telling the truth. And he worked on this case for such a small amount of time, and he gets dragged into this. He gets his health information leaked. He gets not leaked, just basically put out there for the whole world to see.
And his address.
He's being dragged into New York court based on this very strange doctrine that I want you to walk us through, that we walked through the other day. And overall, he doesn't have a lot of money. It sounds not money in he might have money. I don't want to say Mr. Wallace. I apologize if you have money, but he doesn't have money to go and spend a bunch of money on federal court in New York with lawyers, hundreds and hundreds of $1,000s in legal fees. And he's been dragged into this, and I do feel bad for him.
Yeah, especially if you do look at his declaration. But the main issue that they're arguing here is personal jurisdiction. And we talked about this a little bit when we talked about the Jed Wallace filings before. And so when you're sued, and when you're a resident of one state and you're sued in a different state, you can't, as a defendant, you can't just be dragged to another state unless you have what we call minimum contacts. And that's out of fairness. It's not fair to force Stewart, who's a resident and citizen of California, to have to go to New York as a defendant unless you've availed yourself of that jurisdiction. You've done something to connect yourself to New York. You've done business there. You've entered into a series of contracts there. You have to show that you did something. But when you're living your day-to-day life and you've had no contact with New York whatsoever, you just can't be sued there. And that's what Jed Wallace is saying, is that, look, I'm Texas. I live in Texas. I work in Texas. I did some work for these people who are in California. I have no connection to New York whatsoever. And so under what we call the long arm statute, you can't drag me to New York to be sued there, even in federal court, because the federal court uses the jurisdiction of the state court. So it's the same jurisdiction, same jurisdictional rules either way. And so that's ultimately the argument. Do you want to talk about?
Yeah, I just want to read this just briefly, and that is Lively's response does not attempt to show personal jurisdiction over Wallace. And again, you need personal jurisdiction to drag him to New York court, right?
Yeah.
And we're setting aside the fact that he actually filed his lawsuit first in Texas against her. She did amend subsequently, and I think included him.
Yeah.
So she's saying it relates back to her filing. No, that's not how it works. But there's no personal jurisdiction here under New York's long arm statute, which you just talked about, but rather her theory of personal jurisdiction, a conspiracy-based theory. So they want it to sound bad from the start. Good drafting of these lawyers from Houston. I don't remember their names. I'll call them out at the end. Is the sole jurisdictional issue, which is whether the Wallace parties are members of the conspiracy. Thus, Lively argues personal jurisdiction is not based on Wallace parties' own acts in New York, because there are none, but rather the acts of others, the co-defendants, under the doctrine of conspiracy jurisdiction, a gloss on personal jurisdiction, where defendants can be subject to personal jurisdiction because co-conspirators' minimum contacts are imputed to the otherwise remote defendant. I mean, this is like you going, can I use you as an example?
Yeah, sure.
This is like you going to New York and really screwing up something, and somebody says to me, well, Keith's your bud, he's your friend, and you guys talked about it, so we're going to impute his acts to you and drag you up to New York, and you're part of this. I just think this is wrong.
Yeah, I think so too. And Jed Wallace points out, first of all, this whole conspiracy jurisdiction argument has not been recognized in every federal circuit. So the Fifth Circuit actually has rejected this, which is the circuit that covers Texas. The Second circuit that covers New York has adopted it in a limited sense, though, is what they're arguing. And the reason it's limited is the conspiracy idea is supposed to supplement the long arm statute, not replace it. And so you can't necessarily drag somebody in just because you're alleging that they were part of some conspiracy. You still have to show minimum contact. So that means the person who's part of this conspiracy has to know that, oh, there's a group of people doing something nefarious or whatever it is in New York. I'm going to join them and help them do that. And I know that all of this is happening in New York, and therefore I'm engaging myself in that action as a co-conspirator. So that would supplement the long arm statute. You've done something to help avail yourself of New York. But I think here the problem that Jed Wallace has is I'm just sitting here minding my own business, doing the work that I do in Texas, and somebody comes along and says, "Oh, you co-conspired with the Wayfair parties. You're in this lawsuit too." It'd be kind of like when we talked to Shasti Flaw. She was talking about how she was in the New York Times article when it first came out because there was some indication that maybe she had colluded with Baldoni and all that, which was nonsense. But they couldn't sue her in New York either unless she had some sort of connection to New York. So I just don't think that their argument works. And the funny thing about it is Lively's making the same argument against Jed Wallace that she doesn't like that Baldoni's make, which is she's trying to lump Jed Wallace in with all the other Wayfair parties. And so that's what she's trying to do. Jed Wallace is like, no, that's not how this works.
Yeah, let's assume that there is a conspiracy going on between some people here. I kind of feel like Jed Wallace, and again, facts have to be proven, but I feel strongly about what I've read in his declaration. It's almost like his friends invited him to go for a drive, and he became the getaway driver to bank robbery he didn't know about, and now he's being charged for conspiracy. And you have to actually intend to be part of that conspiracy in order to be charged for bank robbery. Now, if you choose to be a getaway driver and people are robbing a bank and they go in and kill a bunch of people, you're responsible for those murders the same as the person pulling the trigger because it's a conspiracy. But if you're just going with your friends to the bank and you're dropping them off before you go into McDonald's to get lunch, and they rob the bank and they come running out, I mean, whoa, what's going on here?
Yeah, you're like, where are you going? And they're like, we'll be right back.
So, okay. All right. One other thing is the U.S. Supreme Court has not weighed in on conspiracy jurisdiction yet. So obviously at some point you think they will, and probably won't be this case, but it'd be good to get some further clarification on that. Anything else you wanted to look at here, Keith?
No, not on this one.
Okay. So overall, I actually think that, there is one other thing on Jed Wallace. So the declaration, let's talk about that just for a minute.
Oh, yeah.
So this is a 12B6 phase, and we have to accept everything that Lively says in her complaint is true.
Yeah.
And so what Jed Wallace did is he made a declaration, a very strong declaration, and he's using that declaration basically saying, hey, for the jurisdictional issues, for the venue issues, I think that the court should look at my declaration and include it, not just look to the four corners of the complaint that Blake Lively has made against me. And you'll see the jurisdiction is just so unfair here. And you got to let me, go back to Texas. By the way, he did file first in Texas against her. So what do you think about the declaration? Should the judge take a peek, just a teeny peek at the declaration on the corner of his desk as he's making the decision here?
I think so. And Jed Wallace actually cited to some case law. And here's the reason why I think that the court or the judge can look at it for a limited purpose. And that is to get some context on this whole personal jurisdiction issue. Jurisdiction, especially personal jurisdiction, is a fundamental issue. No lawsuit can proceed until jurisdiction is established. It simply cannot go forward. And if you take a lawsuit forward without that jurisdiction, everything you do in that lawsuit is null and void. It's moot. It didn't happen. So it's such a fundamental and important issue that I think the judge should be able to look at it just to get some context of, is there minimum contacts or is there not?
So the opposite argument, devil's advocate of that, is that, again, the standard at 12B6 is the four corners. And so you shouldn't look at extrinsic evidence, which in fact, the declaration is extrinsic evidence. That's more appropriate for a motion for summary judgment under Rule 56 of the federal rules. And that will be coming. That after we get done with these 12B6s, everyone's like, oh, we're going to trial. No, we're going to more runway. There's more paper to be filed. Yeah. This way, facts will be considered in the next round, where declarations will be appropriate. Testimony from depositions, documents that come by way of discovery that are properly the foundation set on those. All of those issues will be ripe for motions for summary judgment. And that will take us to the next level in this case, because right now, 12B6, this is all complicated stuff and technical, as you pointed out, but a motion for summary judgment, that is some real art that lawyers make.
It's a heavy-duty motion, and you now can bring in evidence. And I would agree with you that you're not normally allowed to look at declarations for any other claim in a complaint on a 12B6 motion, but I think personal jurisdiction is just that important that I think the judge can look at it, at least for a limited purpose, to see if there's truly minimum contacts or not with the state of New York. So we'll see what the judge does with that. Yeah, and do you want to talk about the judge's order on the?
Well, I do want to talk about it.
Okay, you go.
All right, so we've got a couple cleanup comments we need to talk about, and the first is that the court denied Wayfair parties, Baldoni, extra time to amend their complaint if they choose to do so, and also denied their request for an extension on the discovery because they had so much discovery they had to respond to. Yeah. What are your thoughts?
Well, Judge Lyman's a stickler. He's a stickler. And so every party has the right to amend their complaint at least once as a matter of right. After that, you have to go in and get leave of court. And so apparently they have until April 18th to seek leave to amend if that's what they want to do. And here's kind of the interesting thing that I thought about Lyman's order. First of all, he said that the Wayfair parties have been aware of what the opposing parties contend are flaws in their operative complaint for several weeks. And I almost wonder if he's kind of signaling, don't you think maybe you should amend? Maybe that'd be a good thing to do. I mean, I just kind of felt like maybe there was a little bit of a message in there. But it could be that the Wayfair parties do, in fact, want to amend, and that's why they wanted a little bit more time to be able to do that. And the judge is saying, you have until the 18th, file your motion. The judge also quoted, and really what the judge is saying is that you didn't give me any good cause. You didn't give me any good reason to grant this. And he quoted this case, which I absolutely love the name of, Furry Puppet Studio versus Fallout Boy.
All right.
Okay, so I looked this up, and I actually went to, you can go to the website for Furry Puppet Studio. It's pretty awesome. They actually do amazing work. They make amazing like puppets. It's crazy. So there's this case where Furry Puppet Studio sued Fall Out Boy, the band, because Fall Out Boy had 2 llama puppets that were like wearable made for one of their music videos. But the problem is they used it in the music video, but then they used those same characters as part of their marketing, and they put it on merchandise and album labels, and so it was a copyright infringement case, which was really interesting. But the thing that's interesting about this case is that this is what Judge Lyman cited to for his decision, and Judge Lyman also decided the furry puppet case. And in that case, again, the parties asked for an extension of time, and there was a judge that was assigned to the case before Lyman was on it. And they gave the parties, a few more months, whatever it is that they wanted, not as much time as they wanted, but gave them some time. And then the case was assigned to Judge Lyman, and they came in and asked for more time, and Lyman said no. And the reason he said no is 2 reasons. Number one, he says, look, it's the court's job to keep these cases moving as quickly as we can. And so that's what the judge is trying to do. And number 2, you haven't shown me any good cause. You have to show that there is some reason that's not due to your delay and your failure to prosecute the case. And so he was pointing out that here's some examples of reasons that are not going to be good enough to get extra time. Things like carelessness, an attorney's otherwise busy schedule, or a change in litigation strategy. None of that's going to work. So you have to come in and say, hey, we tried our best, and through no fault of our own, we're not able to meet these deadlines, and we want more time. That's what Judge Lyman's looking for on cause, good cause. And so Baldoni's side just didn't say anything that went along those lines. But here's the takeaway. Judge Lyman's a stickler. He runs a tight ship, and he expects people to stick to deadlines.
Yeah, federal judges don't. Well, no judges play. State judges don't play either. State court judges. Federal judges, though, they move quickly, and if they really are going to get to trial in March, there's a lot that has to happen between now and then.
I've never wanted to represent a client more than Furry Puppet Studio.
That's a good one. All right, we should reach out to them.
Yeah.
All right. So one other thing that came up, I think there was this article that came out. I forget the publication. Yesterday, and they basically said they actually saw a subpoena that was issued to Stephanie Jones, but of course it has not been disclosed. Nobody's provided it to us, so we can't tell what case it's tied to, and apparently it was all the way back to October of 2024. What are your thoughts on the subpoena to Stephanie Jones that she's trying to defend herself with?
Yeah, it was in Deadline, and I read that article, and I saw that they actually saw the subpoena, but of course they don't post it. Like, I'd like to see the subpoena. Where's the subpoena? But they supposedly saw it. And they said that the subpoena was issued in October of 2024. Well, we know the first filing in the CRD complaint wasn't until December 20th. The lawsuit's not filed till December 31st. What case did they use to issue that subpoena? There's still a big question mark in my mind about where this subpoena came from and under what authority. And of course, we haven't seen the subpoena, so I don't know. And I went and looked at Stephanie Jones. She filed 12B6s now in the separate lawsuit that she has with Jen Abel. And she claims in those lawsuits that she produced the texts under a subpoena. So it's not like she leaked any information. That's her argument. But she didn't attach any subpoena to her 12B6 motion. It would have been nice to see what she's talking about, but I didn't see anything in the filing at federal court that would shed any light on that whatsoever. So that's great that Deadline saw the subpoena. I haven't. You haven't. Until we see it, it just doesn't make any sense to me where the subpoena came from or what the authority was for releasing it.
Why isn't Deadline publishing the subpoena? I mean, Is there some privacy issue there? I mean, if there's a subpoena and it's got a file number with some court, let's take a look at it and see, is this just a subpoena that was somebody pulled up on their computer and drafted out and gave it to Stephanie Jones, and she's like, oh, I got a subpoena, I've got to give this, or is it actually tied to litigation?
Well, that's what I wonder. I wonder if it was in fact a subpoena, but not one that was officially, connected to any litigation case.
Yeah. So Keith, at the end of the day, I think all these 12B6s, I think, except for the New York Times, I wonder if that one's going to be successful. I think the rest of these can be worked around with some artful pleading.
Yeah.
The New York Times is a problem, but that potentially that could be worked around with some artful pleading as well. But then we're going to get to motions for summary judgment next. The one thought I'm having on 47.1 is, and it's just so unpopular for me to say this, and I don't say this lightly. I'm not being paid to say this, but I feel like this is an albatross around Justin Baldoni and Wayfair's neck that is just going to get heavier and heavier as the litigation goes. And it's almost like you're a prize fighter in a boxing match, and you're allowing one hand to be tied behind your back on purpose just because you're not going to give in on the fact that you can fight with just one hand. And the other prize fighter, even if they're not as good as you, if you're only fighting with one hand and they have both their hands, they're going to make some marks and they're going to make some scores against you. And I think that's what 47.1 is. I think it's allowing Lively to make points against Justin Baldoni, maybe not in the court of public opinion, but in the court that matters from the standpoint of who's going to win and lose here. And that is the court where decisions are going to be made. And so this is not going to get easier with 47.1. Even if somehow, some way Baldoni can plead around and get around the 12b6 through a second amended complaint, now he's going to have to prove, it's threading a needle. I'm very tired right now, so I'm not calling up my good comments.
Well, let's not have you thread any needles.
But please. It's like threading a needle here because you can't overstate the claim because then you have to prove it, right? And so that's the trap that they're in.
There's two very good points of attack that Baldoni has. Number one, defending himself against the SH lawsuit that Lively has brought. He's done an excellent job even so far with the evidence that we saw. The evidence is very convincing. It puts him in a very good light. And 47.1 has nothing to do with that defense, his defense of the SH claim.
He can fight with both hands.
Both hands right in front. Yeah. So 47.1 will not affect that. That's a strong point of attack. The second strong point of attack, Ryan Reynolds. That S predator statement is a big problem for Ryan Reynolds. And, obviously,
even if you don't get Blake Lively, you still have it against Ryan Reynolds.
And I think it's a big problem. And I think, obviously, that's what's alleged in the complaint. You have to prove that it was actually said. But once you have that proof, man, that is a strong case in my mind in terms of both liability and damages. And so if you really want to focus on the two strongest aspects of the case, I think that's where they lie.
So, we're not in this case, obviously, we're not being paid in this case. We're not having to answer questions of clients, but just looking at it from 40,000 feet, if there's some way that Justin Baldoni and the Wayfair parties can withdraw the claim for defamation, and I don't know if
against Lively,
just the defamation claim that they're making against her, they still can vehemently defend themselves against the claim she's made against them, and maybe get a cost waiver from her. I don't know if she would agree to that or not. Then if she won't agree to that, the question is, do you go ahead and do it anyway? Because it just becomes more and more of a problem as you're going along. Look, the prize fighter, if they're going to fight 12 rounds, they can't do it with one hand tied behind their back. And right now I feel like the hand's tied behind the back. And yes, there's this argument of the Norr-Pennington doctrine and the First Amendment. I mean, these are big, weighty arguments that are being made that, will be decided maybe at the federal district court level, but then they're going to go to the federal court of appeal, potentially to the United States Supreme Court. Many people say it won't go that far, but it could. You're talking about millions and millions of dollars in attorney's fees. You're talking about a lot of sleepless nights by the Wayfair parties. Even the billionaire, nobody likes to be facing punitive damages and treble damages and attorney's fees that could be millions and millions of dollars. They've got to figure out some way, somehow to get out of this.
Yeah, because Baldoni could win on the SH claims that Lively has brought against him and just have a slam dunk win. But if he doesn't win the defamation suit against Lively, and it's only the one against Lively that matters, he could be on the hook for tens of millions of dollars if 47.1 stands with the treble damages, punitive damages. Right. I mean, you're talking tens of millions of dollars in this type of case because it's so massive and the attorney's fees are so huge.
Right.
So there's a real risk there. And of course, we all know he has Sorowitz in his back pocket. I get it. The guy's a billionaire. But nobody wants to be in a position of winning and yet also losing. You want to win and you want to win and you want to win.
So if the defamation claim somehow, some way goes away, now Justin Baldoni and Wayfair, they can bring both hands out and they can take, with laser focus, they can defend themselves against the claims that Lively's made. And it looks like they have really good evidence to put in front of a jury to hopefully defeat that complaint or that claim from their standpoint. And then they can also focus in on, did Ryan Reynolds say this? Did he say it on behalf of Lively? That would bring Lively back into the equation. But even if he didn't say it on behalf of Lively and he said it on his own behalf, he's still subject to significant damages for that type of a statement.
Yeah, he's liable for defamation in his own right if that ends up being true and proven in court. So that's why that's such a strong claim. But look, these strategy decisions that we're talking about right now, they're never easy. But it is important that you put it on the table and you get everything out. Like we've said before, you have to turn the crystal and think about what are all the different strategy angles that we can think of. It doesn't mean you're going to go forward with one of them, but you at least have to consider them and think about it and kind of think about how will this shape the case? What's our strongest path forward? And most people cannot withstand a risk of 47.1 treble damages, punitive damages. Luckily Sorowitz is in this case, so Baldoni has, something in his back pocket arguably that most people don't have.
Yeah.
But most of the time when we're talking about this and turning the crystal, it's a real risk. I mean, it definitely makes a difference.
Well, one last question for you. If Brian Friedman had seen this coming, this 47.1 and kind of the havoc it's caused for his clients and his claims, do you think he still would have brought the defamation claim?
It's a good question. I'm not positive. I think that it could have been pled a little tighter in order to keep it to the statute and make it harder to get passed on motions to dismiss 12b6. But yeah, I don't know. Now you're doing the strategy decision before you even file. So yeah, maybe you go ahead and file and fight it out and kind of see if it survives a motion to dismiss. I mean, if you're a gambler and you have the money to be able to support that and take on that risk, then maybe you do file and see how far you can get. I think that there's definitely some room to improve the pleadings. And it's April 11th now? They have until the 18th to file a motion to amend their pleadings. I think there's a good chance we're going to see that.
All right. Well, I apologize that I was not able to use my limited bandwidth today to look at questions as they were asked. And I'm sure there's some great questions that were asked, and we apologize. So put your questions in the comments. We will do our best to respond there. We do appreciate everybody's support, and we will be back probably next week. The judge is going to be making some rulings here soon, and that's really where we can get in, figure out how he's viewing the case and where the case is heading next.
It's going to be huge. I mean, you're talking about 4 different motions to dismiss just on the Lively v. Baldoni case. I mean, when we start seeing some rulings roll in, we're going to get really some good insight into the judge's thinking. And the added benefit of talking to our jury pool next week is producer Eric will be here and be able to help us out with comments.
All right, awesome. Hey, you guys have a great weekend, and we'll see you guys next week.
Take care.
Take care.